Okay. Miss Marlowe, am I live? Miss Marlowe, am I live? Okay. I'm live. Okay.
May I proceed, Your Honor?
You may.
Ms. Satoon, earlier today you were testifying about when you moved out of the property. Do you recall that?
Yes.
And Ms. Satoon, isn't it true that you actually moved out of the property prior to the time that my clients had even made a settlement offer? True?
No, that's not true.
Do you recall Ms. Satoon giving your deposition pretty recently?
Yes.
And do you recall that we asked you when you moved out of the property?
Yeah.
And do you recall telling us that you moved out of the property before Christmas?
Sorry, the internet cut out.
Do you recall testifying that you moved out of the property before Christmas?
No, I didn't move out of the property before Christmas.
Okay. Did you move out right after Christmas?
I didn't move out. I went to visit my sister because she got married.
Okay. I'm going to pull up your transcript. Give me just a moment. Okay. I'm going to share screen, Ms. Satoon, and ask you to look at your transcript starting on page 48. Do you see that Mr. Urtiago asks you, so Ms. Satoon, and I'll highlight it. So Ms. Satoon, it's my understanding from your prior testimony that you temporarily vacated the Maple Springs property right after Christmas 2020, and then you did not return back to the property for approximately 3 months. Is that accurate? And you say, yes, that's accurate. Is that correct?
Yes, I was visiting my sister.
And isn't it true, Ms. Satoon, that you actually were staying in a hotel for 3 months starting at Christmas?
I stayed with my sister for about 3 weeks, and then we had to move to a hotel because it was getting too cramped in there.
And do you recall testifying that you lived in a hotel for 3 months starting at Christmas?
After I moved out of like her townhome, we had to stay in a hotel.
For 3 months, right?
Yeah, until we came back to Dallas.
And you started staying in the hotel prior to the time that the settlement offer was made by Versailles, correct?
No, I think we were still staying with my sister then.
You left Maple Springs in December of 2020, right after Christmas, true?
Yes.
And then you stayed in a hotel for 3 months, right?
Yeah, after I stayed with my sister for 3 weeks. Yeah, we've been in hotels since, so like a long time.
Okay, so you never actually moved back to the property, did you?
Well, we moved out for the buyback, and then no, we didn't move back in.
But Ms. Satoon, you had already moved out at Christmas, right?
No, I didn't move out. I had one suitcase, so all of my stuff was at the property.
Since Christmas, you haven't spent the night a single time at Maple Springs, have you?
Since after, yeah, like the day after Christmas, I think we left.
Sure. You haven't spent the night there one time, have you?
No.
And that started prior to the time that the buyback offer was even made, correct?
Yeah, we went up to see my sister, and then she helped us with childcare and helped us to get through the trial. And then we waited for the buyback, and we came back for it to close.
And you're not working anymore, correct?
Right now, I'm not working. I'm taking care of my children.
And you have not worked in the year 2021, correct?
No, I haven't had any projects to work on.
Well, Have you earned any income in 2021?
No, I haven't.
Do you recall earlier when we asked you if you had earned any income in 2021 and you said you don't know?
I think you asked me, I'm not sure exactly, but
Do you know if you've earned any money in 2021?
I don't think I did. I take care of my two little kids. That's 24/7 job, so I've been doing that.
And your husband's no longer working, is he?
He's working. He's trying to get business and things like that.
And did he start working since your deposition a couple weeks ago?
Oh, sorry. The internet connection isn't very good.
Did he start working then since you gave your deposition a couple weeks ago?
Oh, wait. Sorry. Can you repeat that again?
Did your husband start working since the time you gave your deposition a few weeks ago?
Yeah, he's been talking to clients. He's been trying to get business.
Okay, but he wasn't working during the first 3 months you were in Maryland, was he?
I don't think he really could not. Well, he did talk to investors and things, so he was working on trying to work on stuff remotely. But
Do you recall testifying that he wasn't working during the time you all have been in Maryland, including the first 3 months you were there?
he talks to clients and investors all the time, so I don't really consider it like working per se, but he's always trying to get business. Obviously, it's a commission-based business, so it's not the same as like sitting down 9 to 5 every day. So it's different.
Sure. My question, Ms. Satoon, is do you recall testifying that you and your husband both were not working during the time you've been staying in a hotel and living in Maryland to be close to your sister?
Yes.
Okay. And did you testify earlier today that you moved to Maryland to get help with childcare for your children? Did I understand that correctly?
Well, we initially went to visit my sister. She just got married, and then while we were there, we found out she's pregnant. So, so I was helping her and things like that. And then she offered to. It was kind of unexpected, but going into the trial, we didn't know what to expect. And it's a big feat with two little kids, and you need someone to help take care of them. So she offered to watch them for us, which really helped. And then we ended up staying there longer because we were waiting, for the buyback and everything. So.
And isn't it true that you said you went to Maryland so that your sister could babysit the children?
Oh, well, we initially went to celebrate that they got married. So she got married, and then it ended up into that. So she stayed with us, or she watched my kids during trial.
Ms. Pettit, I just realized, I think the witness that was here from the city, is he here? The gentleman with the city is.
I see his counsel. It looks like he
Your
is.
Honor, we are here.
Yes, sir, I'm here. I couldn't find the mute button, sorry.
It's okay. I was wondering maybe if we could get them on and off the stand so that they don't have to keep waiting.
I have no problem if we want to interrupt this witness to, again, we re-urge our objection. We don't think that anything about city and permits is in any way relevant to this. If
Mr. Scott, I'm going to give you an option here. I tend to agree with Ms. Pettit-Greason. I don't know why they're relevant at this point. If you want to call them now, then this is your one shot.
Thank you, Judge.
And so I don't know that that's in your best interest, but if you want to call them now, great. You want to wait and call them and potentially phase two, if there is a phase two of this trial where this would seem to make a lot more sense, we can do that, but you're not going to get to call them twice.
Well, Your Honor, the only clarification I would ask for is that our trial amendment includes a DTPA claim that is in part based upon this testimony. If we're bifurcating that and going to reserve that to a later proceeding, then I have no problem with calling that witness later.
DTPA based on what?
Based on, this is in the alternative, if the defendants do not buy the property, We are asking for recovery of all of the money that they collected because the evidence will be that the house was illegally constructed and had none of the appropriate permits or approvals.
Well, that's something that has nothing to do with the settlement, correct?
Doesn't have to do with the settlement, but it is in the alternative in our trial.
I allowed a trial amendment based on the settlement. I'm not going to allow a trial amendment on something you could have pled before. So to the extent that that was something you could have pled before, I'm not going to allow a trial amendment on that.
So Your Honor, in that regard, it's newly discovered evidence. It's something that came to our attention after the settlement was made, and it's predicated on the false testimony that was given during the trial, where they defended this defect case on the basis of all of the inspections that they claim were done by the city.
Okay, let me just say this. To the extent that any of that is true, which I question greatly, but to the extent any of that is true, that will not be something we try during phase one of this case. I thought the DTPA was related to the settlement agreement. You're just trying the issue of the settlement agreement at this point, not that allegation. And I'll have to make a determination if you can even plead that. I thought everything was related to the settlement agreement. So with that understanding, do you still need this testimony right now?
Your Honor, is it okay if I call this witness just for a brief examination?
You get one shot.
Okay, then I'll defer to phase two, and hopefully we won't need one.
Mr. Esty, are you there?
I am, Your Honor.
How would be, we obviously want to accommodate you on this, but we're not sure how long phase one is going to last and if there's going to be a phase two. And I apologize for any type of inconvenience here. What would be how would you prefer? What we usually do, I guess, is we will, kind of keep you on like a 2-hour standby. You would not be called today. There's a possibility you could be called tomorrow or Thursday, or your client could be called tomorrow or Thursday. What is your preference?
I personally have a conflict tomorrow morning. I can be available in the afternoon, and I would have to also ask that Mr. McKee be...
Mr. McKee, would you be available tomorrow afternoon?
Hold on just a moment, please.
Okay. Or Thursday. What about Thursday, Mr. Esty?
Your Honor, I'm checking
I
my
have no
calendar
meetings.
as well.
Oh, yeah, I don't have any meetings scheduled tomorrow or Thursday as of yet.
Okay. Mr. Esty?
Your Honor, I have a meeting in the morning on Thursday, but I can be available in the afternoon.
Okay. So we're going to either call Mr. McKee Wednesday afternoon or Thursday afternoon. Just kind of make sure that you keep track of that. And then we're going to go ahead and excuse them for now. So apologize for the inconvenience, and we will we'll let you know. And there's a chance, obviously, that we may not need to hear from you at all. So just FYI.
Thank you, Your Honor.
Thank you, guys.
And Your Honor, we will just wait until we hear from either the court or one of the...
until you hear from one of the attorneys.
Okay, very well, Your Honor.
Thank you, guys.
Thank you.
Thank you.
Thank you. Have a good day.
You too. All right, Ms. Greason, you may proceed.
Thank you, Your Honor. Ms. Satoon, you recall earlier stating that my client sent a TREC contract to the title company?
Yes.
And you recall hearing your lawyer say that my client sent a TREC contract to the title company?
Yes.
Okay. I'm going to show you what I'm going to mark, or what's been marked, Exhibit 125.
Oh, I need to enable this, I think. Let me see. No, it's enabled.
1 second. Let me look at there. Okay, here we go. Do you see Bates numbers in front of you, starting with Trinity 3073, which is a part of Exhibit 125?
I didn't share whatever you did.
Okay, let me try it again. It shows on my end. Give me 1
Does anyone else see it?
No, Your Honor.
Okay, there it is.
Now it's coming up.
Okay. Do you see this? It's Exhibit 125, and it's Bates number Trinity 3073 through 3088. Do you see a document in front of you?
Yes.
Okay, and if you scroll down to the second page, you see this is communication between Sam El-Shami, the title company, Mr. Lambert, and myself. Do you see that?
Yes.
And Ms. Cross says the assignment needs to be addressed in the contract and should have buyers' names and or assigns. Hope this helps. Do you see that?
Yes.
And then I respond on March the 1st, and I say to Ms. Cross, what contract are you currently operating under? Do you have a contract? It was my understanding that you all did not require a contract. Do you see that?
Yes.
And then you see that Ms. Rubeck responds from Trinity and says, here is the contract. Do you see that she says that?
Yes.
And if we look at the attachment, oops, give me just a minute. The attachment is page 3079. Give me just a moment. We see that the title company sends me a contract after I ask what they're operating under. And we see this, the Trek contract with your name on it. True?
I wouldn't know. I really didn't. I don't think I've seen this actually.
Did you authorize your attorney to send a Trek contract to Trinity Title?
I didn't. I thought we were doing this. It was just the settlement agreement that was at the title company, and that's what I thought they were referring to back then. So I wasn't. I don't know.
Sure. So even you thought that there was no contract, no Trek contract that was going to be involved, right?
That was my understanding. It was the settlement agreement that was over anything. I believe Judge Hoffman even mentioned something about this in one of the things that we were talking about this beforehand.
All right. But you see in the exhibit that we were just looking at that it was the title company that sent this contract to me. True?
Well, I don't know exactly because I don't know if it's what the exact, like it has a lot of attachments there. I don't know.
Well, there's just one attachment and then her photos would show up as attachments, right?
I mean, I guess it says contract or contract PDF, but I don't know. I mean, I wasn't talking to any of these people, so I don't know exactly how it, what, how it all happened. I'm not sure.
So if you earlier testified that it was my client that originally sent a Trek contract to Trinity, you don't have any evidence to show that it was indeed my client, do you?
I didn't say originally. I said that there was this, it seemed like I saw later on that there was this Trek contract that was added like 15 pages to a standard Trek contract. And it wasn't sent to us, but it was sent to title.
It's your testimony that you've seen 15 pages attached to a Trek contract that was submitted by my client?
I think it seemed like it was large, but I didn't really read it at all. So I don't know.
Okay,
Exactly.
well, I hope that your attorney will certainly present that to your honor, if that's to Judge Hoffman, if that's indeed the case. Okay, I'm going to move on, Ms. Satoon. This email that we looked at a moment ago before the break, I want to look at the first paragraph and then look at the second paragraph for a moment. So what you say here, or what your attorney says here, right? So this is from your attorney to me. True?
Yes.
Okay. Your attorney says, what I am saying is that under the statute, your client is responsible for the Zatoon's moving costs, expert costs, and legal fees. And I'm merely asking if your client is willing to pay the real estate taxes as a trade-off, and a very favorable one for your side at that. It's merely an offer or suggestion. Did I read that correctly?
Yes.
And then your attorney says, if your answer is no, that's fine, and I'll reserve our rights on those issues. Isn't that what your attorney said?
Yes.
And then when we look at paragraph 11 of the only release you signed, there's a carve out that says this release does not apply to claims or causes of action if the opposing party fails to strictly comply with its statutory obligations. Did I read that correctly?
Yes.
And you all signed that after your attorney on March 4th had told me that under his interpretation, we also had to pay moving costs, expert costs, and legal fees. True?
I think that's what that, or what it's highlighted, yes.
Okay. Now I want to look at, and other than that release that you all signed that we just looked at, and the one that's in Exhibit 129, you never signed any other release, correct?
I don't remember, but I don't think so, but I'm not sure.
Okay. Let's look at Exhibit 129. That's Bates number 8293 through 8298. Do you see that here on March the 5th? I am sending a release and confidentiality agreement to your attorney.
Yes.
Okay. And if we look at it here, you all never signed this release, did you?
I don't know.
Do you recall signing this release?
I really don't remember exactly what I signed.
Well, if you had signed it, you certainly would have produced it in this litigation, true?
True. So
Okay.
Yeah,
So if we don't have a signed version, then it's fair to say you didn't sign it, right?
I would think so, right?
Okay, so if we look at the actual substance of this release, it's got some definitions and then has a release by plaintiffs, right?
Uh-huh.
A release by defendants, true?
Yes.
And a confidentiality provision, right?
Yeah.
And then just some governing law and other miscellaneous provisions, true?
I guess so.
And you've never seen a signed version of this, have you?
I don't think I signed it. If I didn't sign, if it's not produced, I guess I didn't. I don't know.
All right, let's look at Exhibit 125, Bates numbered Trinity 3427 through 3430. Do you see this as an email from the title company to your counsel on March the 5th?
Yes.
And the title company tells your attorney that day, because your attorney has first emailed and says, have the buyers wire the 1.1 million in funds. Do you see that?
Yes.
And the title company responds and says they would like a final HUD, etc. finalized, and they said they can wire within 30 minutes once all parties agree. Did you see that?
Yes, I see that.
So the title company had told your attorney on March 5th that the buyer could wire within 30 minutes once all parties agree. True?
True.
Okay. Now let's look at what happens on March 8th. This is an email. It's Exhibit 125, Bates number 969 through 972. And the title company tells your attorney that day, the assignor wants a deed straight from sellers to them, right?
Yes, that's what she said.
And them is referring to 2808 Maple Springs, right?
I would assume so.
And she says attached is an estimated HUD-1. They're also wanting prorated taxes, right?
Mm-hmm.
And Ms. Atun, you know that in order to close a transaction, you have to have a signed HUD-1, right?
Yes.
Then let's look at the HUD-1 that was attached. And the HUD-1 is Exhibit 125, Bates numbers Trinity 2264 through 2266. And it shows that the buyer on this HUD-1 is 2808 Maple Springs, right?
Yes.
And you and your husband never signed this HUD-1, did you?
I don't think we got there yet.
And in fact, you all never signed any HUD-1, did you?
No, that we didn't get there yet with the title company.
And you know you can't close a transaction, as you just mentioned, without signing a HUD-1, correct?
Well, we can't close we can't close the contract either without escrow money or money in escrow.
Mr. Toon, you can sign a HUD-1 before the money is wired to your account, true?
Well, the money wasn't at title, so I don't understand why I would sign all these papers.
Mr. Toon, how many real estate transactions have you closed?
None.
I will ask your husband then. Who is Christina Lucio?
I have no idea.
Do you know why your attorney had put a $25,000 fee to be paid from your closing proceeds to go to a Christina Lucio?
Your Honor, this is invading attorney-client privilege. It's just an allocation of fees to my partner.
Mr. Toon, to the extent that this wouldn't, let me just instruct you that you have an attorney-client privilege. To the extent that this would invade your attorney-client privilege, and the only way you learned about this was from your attorney, I instruct you, you have the right to refuse to answer it on that basis. If you learn this in some other way, or you know something about this in some other way, then you can answer it, but otherwise you're allowed to assert a privilege.
Okay, thank you.
Mr. Toon, do you know who Christina Lucio is?
I don't know what you're referring to.
Have you ever heard or met a Christina Lucio?
Ms. Greason, I don't see on this page who Christina Lucio is.
I'll get there, Your Honor, but I'll go ahead and scroll down. On line 1305 of this exhibit, Ms. Toon, do you know who Christina Lucio is?
I'm not familiar with the name, but it looks like legal fees.
Do you know why your attorney was paying $25,000 from your closing proceeds to a Christina Lucio?
Same objection, Your Honor.
Same instruction.
I wouldn't know.
Are you aware, Ms. Toon, that anyone by the name of Christina Lucio is not even licensed to practice law in the state of Texas?
Objection, Your Honor. I don't know what this has anything to do with this case that we're trying.
Yeah, Ms. Petta, how does this relate to what we're trying?
Well, there's a HUD that was never signed, trying to figure out why it wasn't approved and why the Zatoons didn't sign it, and certainly why from closing proceeds, Mr. Scott is trying to pay some unlicensed non-attorney $25,000 from the Zatoon settlement proceeds.
I know what you're getting at. I don't know that particular question is relevant, but there may be some other question related to this that would be.
I'll move on, Your Honor.
Okay.
Okay, going back up, Ms. Zatoon, to the email that contained this attachment, when the title company, said the assignor wants a deed straight from the sellers to them, to your knowledge, that was never drafted or signed, correct?
I'm sorry, I couldn't hear the last part of the question.
Sure.
I couldn't either.
My apologies. To your knowledge, Ms. Zatoon, was a deed straight from sellers to 2808 Maple Springs ever drafted or signed?
I guess the deed was drafted with Versailles, Dallas, and a sign or something.
So that's a no.
The deed was drafted the exact way that you wrote it in the settlement agreement.
So that's a no. There was never a deed from the sellers to 2808 Maple Springs LLC.
No.
Ms. Zatoon, are you reading something on your screen today?
Yeah, I'm reading what you have in front of me.
Okay. All right, I'm going to show you the next exhibit, which is Exhibit 125, Bates number Trinity 990 through 995. And you see this is an email from Trinity Title to your attorney.
Object?
I'll zoom in.
Sorry, I see it.
Do you see that, Ms. Atune?
Yes.
Okay. And you see it's dated the date of closing.
Yes.
And if you look at, well, let's start here. So the title company says to your attorney, seller, being you, the Zatoons, would have to agree to that since the contract was not made to buyer and or assigned. Did I read that correctly?
Yes.
And then she says, in order to satisfy TDI, which is Texas Department of Insurance, we have to close using the parties on the contract. If they just wrote in the new buyer's name and all the parties initialed it, that would allow us to close directly into buyer two from seller. And since there's no lender involved, there really is no problem for us to do that, correct?
That's what that says. Yes.
Sure. So the lender had no, excuse me, the title company had no problem with the deed going directly to 2808 Maple Springs, true?
Objection.
I don't know.
Overruled.
Okay, let's look at the next exhibit. This is exhibit 125, Bates number Trinity 1055 to 1058. You see another email from Miss Chris, true? Do you see that?
Yes.
And you see that I asked on the closing date to Miss Chris, have the Zatoons approve the revised HUD? And her response is, they have not. You may want to reach out to Jonathan Scott as they do not agree with the deed from sellers straight to 2808 Maple. Did I read that correctly?
Yes, that's what she said.
Now let's look at exhibit 125, Bates number Trinity 120 through Trinity 125. This is an email from me on the date of closing to Miss Chris and your counsel, true?
Yes.
And I tell your counsel several things. I say, first, I understand you've not approved the HUD, right? You had not approved the HUD as of the closing date, true?
I don't think we got there yet, so it wasn't that I didn't approve it.
Well, had you approved a HUD by March 8th?
We were waiting for the money to be at title, so we didn't get there yet.
Okay, so that's a no. You had not approved a HUD by March 8th.
I don't really know.
All right. Number two, I say, as you know, the settlement allows title go to Versailles and or assigns. See number 3 of settlement that states execution of general warranty deed by the Zatoons to Versailles and or assigns. We understand you're not allowing this. Did I read that correctly?
That's something that you wrote, yes.
And as of March 8th, you had not signed a deed to 2808 Maple Springs, correct?
The deed was written exactly how you wrote it in the settlement agreement. So it said Versailles, Dallas, and or assigns.
So that's no.
You'd have to ask the title company if that would be an issue. I really don't know.
Ms. Atune, you never signed a deed to 2808 Maple Springs, did you?
Sorry, what'd you say? The internet?
Sure. You never signed a deed straight to 2808 Maple Springs, did you?
Oh, sorry, I can't hear you.
Sure. You never signed a deed straight to 2808 Maple Springs, did you?
Did I never assign something?
You never signed a deed putting title in 2808 Maple Springs, did you?
I don't know if you need to. It said Versailles, Dallas, and or assigns.
Objection non-responsive, Your Honor. I'm not trying to draw this out, but I just need an answer to this simple question.
Ma'am, you need to answer the question.
No, I didn't sign a deed to 2808 Maple Springs.
Okay, then number 3 in my email, I say we cannot have a warranty deed that says your clients are not responsible for their own past due taxes, right? That's what I said?
Yes.
And you and your husband never signed a deed that did not contain the carve out for past due taxes, did you?
I'm not sure.
Okay, if you had signed one, it would have been produced, true?
Yes.
Okay, and then on number 4, I say we need the attached confidentiality release to be signed, right?
Yes.
And on March 8th, you all never signed the confidentiality and release agreement other than the one that we've looked at that your attorney drafted. True?
Yes.
Let's move on to Exhibit 125, dates numbered 1084 through 1089. This is an email on the 9th, so the day after closing. True?
Yeah, it should have funded by then.
And it's from your attorney to me and the title company, right?
Yes.
And your attorney says this. He says, Kenneth Lambert PE and 2808 Maple Springs LLC are not parties to the statutory buyback or the settlement agreement. We have no idea who Mr. Lambert or 2808 Maple Springs LLC are, and the Zatoons will not enter into new agreements with a stranger to the court settlement. Did I read that correctly?
Oh, sorry. Was there a question?
Did I read that correctly? Those 3 highlighted bullet points.
My internet is going in and out. I'm sorry.
Sure. Did I read those 3 bullet points correctly, Ms. Zatoon?
Can you hear me?
Yes. Can you hear me?
Yes. It was just internet's going in and out though.
Okay. Do you think I read those 3 bullet points correctly?
Yes.
Okay. And that was you and your husband's position as of March 9th, 2021.
Yes, that looks like the email there.
And I now want to look at Exhibit 129, dates number 8869. Do you see this email?
Yes, I see this.
And so now we're 2 days after closing, right? March 10th.
Yeah, it should have funded by then.
And I say, Jonathan, the assigns of Versailles Dallas Inc. are ready, willing, and able to close and wire the funds immediately. The issues from my prior email still remain. Did I read that correctly?
Yes.
And then I list the same 4 problems that I listed in my prior email. True?
Yes.
And those issues to this day have not been resolved, correct?
Well, the deed was drafted, the exact same way that the settlement agreement was written. And the HUD, we didn't get there yet. And the funds weren't funded. So I guess we didn't get there. I don't know.
Okay, so as of March 8th, just to recap briefly, as of March 8th, you still owed the 2020 taxes on your home, right?
I think so.
And the deed that you had signed had a carve out for unpaid property taxes, true?
I wasn't sure of it, but I guess you're saying so. I don't know.
And you had not signed a deed to 2808 Maple Springs, right?
We signed a deed to Versailles Dallas Inc. and or assigns.
And the only release that you had signed is the Exhibit 129 that we looked at, in which there's a paragraph saying that you all were not releasing Versailles or any alleged non-compliance with the RCLA, correct?
Could you say that again?
Sure. As of March 8th, the only release that you had signed is the one that we looked at, in which there's a carve out for non-compliance with the RCLA, correct?
Yes.
I pass this witness, Your Honor.
Do you redirect?
Yes, Your Honor, just briefly. Aaron, you were showing a whole bunch of documents, a lot of emails from Ms. Pettit, from their side, in terms of their take on what was going on. Your Honor, can I share screen?
You may.
Is everyone able to see this?
Yes?
Yeah.
Your Honor, this is Plaintiff's Exhibit 118. And do you recall, Aaron, that Ms. Pettit asked you extensively about discrepancies in the legal description for the property, two parcels instead of 4? Do you remember that?
Yes.
I'd like you to take a look at read here paragraph A to yourself. Tell me when you're finished reading it.
Okay.
So is it your understanding that no later than February 22nd, 2021, the Versailles and the El Chamiz Council was advised in writing that the legal description for the property had been corrected and confirmed by Trinity Title for 2808, the property of 2808 Maple Springs?
Yes, it was.
Was it also true, take a look at B, was it also true that you made arrangements for the keys to the residence to be sent to Trinity Title on or about February 21st, 2021?
Yes, that's right.
In C, is it also true that as of February 22nd, a general warranty deed had been sent along with the keys to be held in escrow for the closing at Trinity Title?
Yes, that's right.
Was it also the case, Aaron, as said in D, that Trinity Title had at this point issued a full title commitment that included a search for any liens that existed on the property as of that time?
Yes.
And is it correct that the liens that were found by the title company at that time consisted of a first mortgage with Ally Bank and 2 Dallas County mowing liens?
Yes.
And do you see in D that there's a reference to an offer that under the statute, these would be paid from the first proceeds at closing?
Yes.
And so if the Versailles and the El Chamiz had funded this transaction and paid the $1.1 million balance, would you and your husband, Jordan, have applied that money to pay off these liens?
Yes.
And in E, was it your understanding that Trinity Title issued issued a commitment for title insurance in favor of Versailles Dallas Inc. as the buyer of this property, the residence of 2808 Maple Springs?
Yes.
And is it your understanding that that title insurance protected Versailles Dallas Inc. and ensured that you were not only passing title free and clear of any liens at the closing, but that the description of the property was guaranteed to be correct and accurate?
Yes.
Sorry, Josh, just bring this faster. While I'm doing this, let me ask you a question. Do you recall the council asked you whether or not you and your husband signed a deed from Aaron and Jordan Zatoun to 2808 Maple Springs?
Yes.
Can you tell me whether or not in any of the exhibits that Ms. Pettit showed you, there was actually a deed that was prepared that was sent to you, your husband, or your counsel in favor of 2808 Maple Springs with a request that it be signed?
Not that I know of.
Did you see any in all of those exhibits that Ms. Pettit showed you earlier in your examination?
No, she showed me some other documents that she prepared, but not that one.
Oh, sorry, I went right past it. So Aaron, I'll represent to you that this is the title company commitment and the legal description in item 4. And can you tell me whether or not you remember earlier, Ms. Pettit was asking you about a legal description that only conveyed lots 1 and 2. I know you're not a surveyor or anything, but to the best of your knowledge, is this the legal description that the title company prepared that would have been used to close title on this property, assuming that provided that that Versailles and the El Chamis had wired the funds to close the transaction?
Yeah, it looks like this is, I don't know legal descriptions well, but I mean, it looks like that is the correct one, I would say, if they, funded the deal, that would have been used.
And after February 23rd, 2021, at any point in time, did you, or to your knowledge, your counsel, communicate to the title company or to Versailles and the El Chamis that your intent was to use a different legal description than the one that we're looking at right now on this exhibit?
No, my intent's not to use a different legal description.
And Aaron, can you tell me whether the title company ever sent you a final HUD-1 and requested that you sign it in advance of the closing?
Oh, sorry. Can you say that again?
Can you tell me whether, Aaron, can you tell me whether or not Trinity Title ever sent you a final HUD-1 in it that they requested that you sign before the closing took place?
Not that I know of.
And you recall that Ms. Pettit showed you an email that I wrote early in March, a few days before the closing, in which I indicated that we did not know who Kenneth Lambert was and we didn't know who 2808 was, and that they were strangers to our settlement agreement?
Yes.
And do you agree that they were in fact strangers to the settlement agreement and to you and your husband?
Objection vague, objection legal conclusion. I'm not sure what strangers to the settlement agreement means, but in the event, I think it's for the court to decide.
Yeah, it's sustained.
Let me ask it this way, Aaron, on or about March 5th, had Kenneth Lambert contacted you or your husband and introduced himself?
No.
Had Kenneth Lambert contacted you or your husband and sent you any contracts, sales contracts to buy your property?
No.
As of March 5th, 2021, had Kenneth Lambert contacted you and given you any documents that reflected that he had the financial capability to purchase your property for $1.3 million?
No.
And Aaron, you've seen attached to a motion, an emergency motion that was filed on or about March 15th by Versailles, in which they attached a bank statement, or what they represented was a bank statement for 2808 Maple Springs as an exhibit. Do you recall that?
Yes.
Prior to that March 15th filing, had you and your husband ever seen any financial information or background information with regard to Kenneth Lambert or 2808 Maple Springs?
No, it wasn't given to us.
Okay. And can you tell us, Aaron, whether or not Mr. Lambert has ever come to your house at 2808 Maple Springs to your knowledge, and toured the property?
No, I don't think he's ever been there.
Do you know whether or not Mr. Lambert or 2808 Maple Springs were present at either of the two inspections of the property that took place with Versailles on January 5th, 2021 and on March 5th, 2021?
No, he wasn't there.
Okay. Okay, bear with me. I'm just going to pull up another exhibit. Okay. We need 118. Oh, it's further down. Second. Oh, I'm looking for, sorry, Your Honor. Second. 118, I'm looking more.
While he's trying to pull that up, Ms. Pettit, are you there?
Yes, Your Honor.
There's an email that you referenced, 3/10 of 21, where you listed out a series of deficiencies.
Yes, Your Honor.
What exhibit number was that?
Yes, one moment. It was actually, yes, it is exhibit 129. And then within exhibit 129, it's Bates numbered 8869.
And was
And
there ever a response filed to that email?
Well, Your Honor, if I may back up a little bit. So the same 4 points were in the exhibit that I showed Your Honor, or that I showed the witness, exhibit 125.
Okay.
And that's, so exhibit 125, within that exhibit, it's Bates number 120. And Mr. Scott's response,
I'm about to show it, Your Honor.
I
Okay.
showed Your Honor, and that had the 3 highlighted portions that Ms. Satoon listened to me read out loud. That can be found at exhibit 125. Bates number 1084 is his response.
Exhibit is 125, 1084, his response. Okay.
Yes, Your Honor.
You said you already went over that?
With Ms. Satoon, yeah, it was the 3 highlighted sections. I can, and redirect, or I guess recross, I'll likely ask her briefly about that. So I'll have it back up on the
Okay.
screen, Your Honor.
Your Honor, that was one response, but there was another response that was in the defendant's exhibits, but I also have it in my exhibits. It's plaintiff's 118. I have
Okay.
it on the screen right now.
And this is the response right now? Okay.
Yes. So, Aaron, do you recall that Ms. Pettit asked you whether or not the deed was changed to accommodate their request that for an ad valorem tax adjustment, so that the 2020 taxes would be charged as a closing cost to you and your husband?
Yes.
Your Honor, I hate to jump in, but I want to be clear that this isn't answering Your Honor's question, because this email is dated the 12th, which is much after what Your Honor had asked in regard to what Mr. Scott's response was. I understand that after the fact, they tried to remedy when they realized they'd blown the deal, but the date that Your Honor is asking about is not accurate that we're looking at.
So this email here that's on the screen is after the deal fell apart?
Yes, Your Honor. I showed Your Honor the one that happened right before the deal, or the day after it fell apart.
Okay.
Mr. Scott responded, but this is way after the fact. The deal was supposed to close on the 8th.
Well, Your Honor, that's a little bit hard to accept, considering that on the 12th, they filed an application saying that they were ready, willing, and able, and the deal was still alive, and came before the court on March 22nd, saying that they wanted Your Honor on an emergency basis to order that the closing go forward.
Is that right, Ms. Pettit?
Our motion was filed on the 12th, I believe, and as I represented to Your Honor then, we didn't know if the individual who was going to fund it was still willing to or not. When we filed the motion, we believed that he might, if the issues could be addressed, but they were not addressed. Those 4 points that we brought up were not addressed prior to the time that the buyer decided he was no longer willing to be involved with Mr. Scott in this transaction.
Okay, all right. I'm sorry. I'm getting distracted here. Let's
right.
finish this examination.
Sure. Okay, thank you, Judge. So Aaron, the last deed that you and your husband executed, did it remove the that warranty carve out with regard to the 2020 taxes?
Can I see the document maybe if you have it?
Sure, that's Exhibit 116. 1 second. Whoops. This thing is what's that? Okay, where's that? Here? Let's see if I can do it this way. Okay, so this is Exhibit 116. And do you see the language? The conveyance is executed, delivered, and accepted, subject to ad valorem taxes for the current year, rollback taxes due to this conveyance, or grantee's use of the subject property.
Yes.
Okay, and so that's different than the language in the earlier draft deeds, correct?
Yes.
And so at this point, in this paragraph 1,
Mm-hmm.
had we offered to, in order to resolve Ms. Pettit's objection, to change the deed so that it reflected that you and Jordan would pay from the closing proceeds your real estate taxes.
Yes.
And at this point, on March 12, 2021, on Friday, Ms. Pettit showed you documents where various statements were made about people intending to send money to the title company. To your knowledge, was any part of the remaining balance sent to the title company, whether it was from Ken Lambert, 2808, Versailles, or the El Chamis?
No money was ever sent to the title company to fund it.
And Aaron, when in the third sentence here where it says the alternative deed will be a Trinity title and escrow on March 15th, 2021, did you and your husband execute the deed, which we just looked at, and the March 12th deed, and FedEx it to Trinity Title?
Yes.
And do you see here where my cursor is? After Versailles and the El Chamis perform and close with the Zatoons, they can at any time sell the residence or transfer title to whomever they choose.
Yes, that's what I was trying to explain to Miss Pettit earlier.
And can you elaborate when I want to give you that opportunity to explain to the judge what it was that you were trying to explain to Miss Pettit earlier?
Well, it's like coming to the table as like a dual closing. So Versailles Dallas could have came to the table and simultaneously sold the property to 2808 Maple Springs, signing it right then and closing the deal, and Mr. Lambert could have bought it right then also in that way.
And can you tell me whether or not, to your knowledge, these offers that were made on your behalf and on your husband's behalf by your counsel were ever responded to or accepted by Versailles, the El Chamis, or counsel on their behalf?
No, I don't believe so. Or, yeah.
And Aaron, can you tell the court whether or not a few days prior to closing, the El Chamis and Versailles Council demanded that you sign a settlement, that you sign a release as a condition to their funding the transaction for the purchase of the property?
Yes, Miss Pettit showed me the release that she wrote.
And was that release presented to you through counsel prior to the time that anyone on their side had wired any money to Trinity Title?
Sorry, the internet connection. Could you say that again?
What I was asking, Aaron, is can you tell the court whether or not that demand that you and your husband sign a release was prior to the time that any money was sent to the title company by Versailles, the El Chamis, or 2808 or Ken Lambert?
Yes, they demanded us signing those documents before any money would have ever came to the title company.
Okay, and at the time that the defendants demanded that you and your husband sign a release, had they, besides the thing we've already covered, which is that they didn't send in any money, what about the other items in the settlement agreement that were their responsibility? So do you recall that one of the items in the settlement of the 7 items that were involved, that one of them was that they were required to dismiss or withdraw their appeal in the earlier case? Do you recall that?
Yes.
And can you tell the court whether or not at any point prior to March 5th, March 8th, or March 12th, Versailles or the El Chamis provided you with any written document that would effectuate the dismissal of their appeal in the earlier case under the settlement agreement?
I can't remember. Not sure.
So, Aaron, as far as you're aware, or are you aware that the El Chamis and Versailles are continuing with their appeal in the Fifth Court of Appeals and have now asked the court for an extension of time?
Yes, they have.
When you said earlier in your testimony, Aaron, that we never got there with regard to certain documents and in terms of the status of the closing, can you be more specific or explain to the court what you meant by those words?
Well, we signed, we signed the deed exactly the way that they wanted it, Versailles, Dallas, and/or assigns. And we changed, I guess, these valorium taxes to, we tried to accommodate exactly what they wanted. And yeah, I think we never got to the HUDs and stuff because the deal never got funded. We just never got there.
And so to the extent that Ms. Pettit is either arguing or suggesting or claiming that you and your husband refused to sign the HUD statement, and that's the reason why this transaction did not close, is that correct?
No, I never refused to sign anything.
Aaron, did you ever refuse to, were you ever presented with a deed from you and your husband to 2808 and then at any point refused to sign that deed?
No.
And if the court were to decide that the proper way to document this buyback would include that the deed should be in a different form than the 3 deeds that you've executed, are you ready, willing, and able and prepared to execute whatever deed His Honor feels is appropriate?
Yes, I'm willing to do anything that Judge Hoffman decides that if we can get this deal across the finish line, please let's do that. We need to have the buyback happen. We're in a really bad scenario. So anything that we can do, I would do.
Your Honor, thank you. Aaron, I pass the witness.
But before you move on from that, I had a question for Ms. Satoon. Can you see where I'm referencing here, where the sentence that says, therefore kindly advise your clients to stop asking the title company to send us documents pretending as if the Zatoons are selling their house to a third party in a private sale? Do you see that sentence?
Okay, I think let me read this. Yes.
So it was your position that you would not agree to this deal if it was going to be, if this house was going to be sold to a different entity?
That's it. Actually, it wasn't my position to not sell it to a different entity. It's more of like protecting our rights of what happened is Sam, I guess, called into the title company and wanted Versailles Dallas off of all of the documents. And that, I guess by doing that, we could enter into another agreement, I guess. Like, it's almost like taking the settlement agreement off the table and entering the agreement with a third party that we don't know about. And you kind of lose all your rights and things like that. We were very concerned about that.
So this was something that your attorney was representing to the other side on your behalf. You were basically refusing to do the deal if it was going to be with a third party.
Your Honor, that would invade attorney-client privilege, and I
Okay. Well, I mean, okay. I'm not telling you what your attorney asked you. I'm asking you, were you refusing to do this deal if it was going to be with a third party?
No. No, definitely not.
Okay. All right. Go ahead, Ms. Pettit.
Mr. Scott, can you stop sharing your screen so I can share mine?
Oh, sure. Sorry.
What exhibit number and page was that? Exhibit 125? No, that was exhibit 118. Is that correct?
The exhibit we were just referring to, Your Honor, is plaintiff's 118. Yes.
Minus 118. And what page in that?
That is page 29 of 33.
Okay. All right.
Ms. Satoon, do you have on your screen an email that we looked at a moment ago, which is exhibit 125, dates numbered 120 through 125?
Yes.
And you see this is where I laid out the 4 issues that we had as of March 8th, the closing date?
Yes.
Okay. And do you see that on March 9th, the day after the closing date, your attorney responded?
Yes.
And do you see that Mr. Scott said on your behalf, look at the 3rd bullet point, the Zatoons will not enter into any new agreements with a stranger to the court settlement. Did I read that correctly?
Yes.
And Mr. Scott was representing you at the time
Yes.
and sent this on your behalf?
Yes.
Okay. Do you see the next day, March 10th? So 2 days after the settlement, I respond again and lay out the 4 same issues. Do you see that?
Yes.
And you testified that you weren't willing to sign a release, but isn't it true that you just weren't willing to sign the release that we had drafted? You did sign a release that your attorney had drafted, true?
Yes, we did.
And you indicated to the court a moment ago that you didn't want 2808 Maple Springs to be a party because that means that you are releasing all of your rights as to Versailles, correct?
It's not necessarily not wanting them to be a party. It's just that, yeah, we just don't want to be tricked again. We just want them to buy the house.
Isn't it true, Ms. Satoon, that the the release agreement proposed to you by our side, of course, included Versailles as a party? You see that?
So can you ask the question again? I do see
Sure.
that.
Isn't it true that this exhibit that we looked at has a confidentiality agreement that our side drafted, in which, of course, your Dylan El-Shami, Samuel El-Shami, and Versailles are parties? True?
Yes.
And there's no evidence that you can point to that we ever asked that these individuals not be part of the final settlement documents. True?
You'd have to ask the title company about that.
You've never seen one, have you?
I guess when the title company testifies, they'll talk more about that.
And isn't it true, Ms. Satoon, that back at the time of March 8th, you cared who the money came from, but now that we're in front of the court, you no longer care if the money comes from 2808 Maple Springs LLC. True?
That was never really the issue. It was just more about funding the deal.
Isn't it true, Ms. Satoon, that you refused to sign a deed to 2808 Maple Springs as of March 8th?
Well, I guess I didn't even refuse because I guess now that I'm reminded, I was never even presented one.
And that's because in the exhibit we just looked at, your attorney instructed me to stop sending documents to the title company that included 2808 Maple Springs. True?
Objection, Your Honor.
Overruled. Ms. Pettit, I get it. I get this.
I passed the witness, Your Honor.
Julie, can you please leave this exhibit up?
Sure.
Can you scroll down? Just briefly, Your Honor. Next page, please. So, Aaron, do you see in paragraphs 2.1, 2.2, there's underlined language here?
Yes.
And do you see that it says the release explicitly does not include any duties or obligations created by this agreement?
Yes.
So did this agreement, to your knowledge, I know you've just reviewed it during your testimony, did this agreement have anything in it that stated what Versailles Dallas and the El-Chamis were going to do under the settlement agreement? Did it carve that out or state in this release that they would still have to do those things or not?
Objection, vague, compound, legal conclusion.
I don't understand the question at all either.
All right,
So I would just state the objection.
Let me rephrase it.
And Your Honor, I believe she just testified that she's never even seen this document before.
I don't think that was the testimony, but let me rephrase it. So, Aaron, this document, this confidentiality and settlement agreement that the El-Chamis and Versailles required be signed, can you tell me whether or not you see anything in here that has to do with their obligation to pay the remaining balance, to withdraw their appeal, to do any of the other things in the settlement agreement?
Yeah. So it looks like they wanted us to sign this document. It releases explicitly does not include any duties or obligations created by this agreement. And then we have to, once we sign this, we wait for them to fund the deal.
And so when you said before that you had concerns about signing this release and confidentiality agreement, can you tell the court what your concern or concerns were? What could happen? What were you worried about, if anything?
Objection, Your Honor. She's testified that she is not familiar and doesn't know this document. So for her now to sit here with concerns, this lacks any foundation.
I tend to kind of agree with that, but if you had concerns, if you specifically had concerns about this agreement at the time, can you convey those? Ms. Zatoun?
Oh, yes. Hi. Well, it's interesting that they want us to sign all of these releases and things, but then they didn't want to.
Ms. Zatoun, listen to my question, which is, did you have any concerns about this confidentiality and mutual release at the time that it had been presented to you?
Yes, I mean, I was concerned that we would sign all our rights away and then they wouldn't fund the deal and we'd be stuck.
Okay. All right, let's move on.
And Aaron, was that the same concern that you had with regard to their proposal that a third party contract with you or be the responsible party for buying your house back under the settlement agreement?
Yeah, it's alarming if their client's calling the title company and wants to take their name off of everything. I don't mind selling it to a third party, but I don't know how that goes back to the settlement, the RCLA and all that, the buyback. So it's a difficult situation to be in.
One last question, Your Honor. At any point after March 5th, did you or your husband receive any information from 2808 or Kenneth Lambert that made you feel more comfortable that if you sign this release?
Can you repeat that question? My internet was going in and out.
At any point after March 5th, did you or your husband receive any information from Kenneth Lambert or 2808 that made you feel comfortable that if you sign the release, that 2808 would perform the settlement agreement in the place of Versailles and the El Chamis?
No.
Pass the witness, Your Honor.
Your Honor, just briefly. Ms. Zatoun, you heard your lawyer complain about the release agreement that we provided.
Yes.
You see here on March 8th, so when it was still possible to close, I said, provide us with any reason why our agreement is not acceptable. Do you see that?
With any reason why our agreement is not acceptable?
Sure. You see that?
Yes.
I read that correctly. And then I say, we are ready, willing, and able to close, but we must have the agreed upon release and confidentiality agreement. Did I read that correctly?
And sorry, it was my internet. Can you say that again?
Sure. I say we are ready, willing, and able to close, but we must have the agreed upon release and confidentiality agreement, correct?
Yes, an agreed upon one.
And you did not send a revised one other than the one that we've seen of yours that contains that paragraph 11, true?
Yes, but I don't think you guys agreed to it. I'm not sure.
Pass this witness, Your Honor.
Okay. This is going extremely slowly, unfortunately. Let's call your next witness.
Your Honor, I'm sorry, Your Honor. Did you finish?
I'm sorry. I thought you were finished. Were you not finished?
No. Yes, I'm finished with Aaron. I was ready to call my next witness, Your Honor.
Ms. Pettigreeson, were you finished with that witness?
Yes, Your Honor.
Call your next witness.
Your Honor, the plaintiffs call Ed Lang.
Mr. Lang, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, nothing but the truth?
I do.
Mr. Lang, can you tell us, are you associated with Trinity Title?
Yes, I am. I am serve as general counsel. Before you get too impressed, keep in mind I'm the only counsel. So,
So Ed, can you tell us whether or not Trinity Title was engaged by my firm on behalf of the Zatoons in or about February 6th, 7th, 8th, or 9th, 2021, in connection with a statutory buyback agreement in this case?
yes, that's first I heard of it, and I do have some experience in construction law, but I haven't ever run into this statute before. So this transaction kind of stood out as our escrow officer at the time. I think you mentioned Lori Chris, and her assistant was Angela Rubik. But both of them, I recall basically like the day it came in, and it's that time frame you're mentioning, February 6th or 7th or 8th, somewhere in there.
And so can you tell us, Ed, just very briefly for the judge, what is your background and licensure and experience?
Okay,
back to real estate.
Yeah, I'm licensed in, I'm a practicing attorney in Texas and got licensed in Colorado, but I really don't know Colorado law. I just got licensed there. I've been doing, I guess I started out at one of those, at a law firm called Caney Hanger. I was there for about, in 1998 is when I got, 1998 or 9, something like that. But I was there for 6-7 years. Then I switched and went to a different title agency. And that title agency is, I was there for about 11 years and did underwriting. It's a title agency that actually does its own underwriting. So I did title insurance and underwriting. And then I've been in title agency and underwriting since continuously since about 2003 or 2002 or 3, somewhere in there.
And so, Ed, when you made reference to underwriting, can you, just for the record, explain what the role of an underwriter is, particularly as would relate to doing title work as was done in this case?
Yeah, the Trinity Title is a title agency, which means that we are an agent of various underwriters. And you may have heard them. Their underwriters are basically insurance companies like Fidelity or First American. They're usually much bigger companies than the agencies. So we are an approved agent of various underwriters. So the underwriters, they all kind of, they're certainly, I don't know who the underwriter was on this one, but they all play by the same rules. We basically, the title company receipts the contract, and then we examine title based upon what we received. And it changes. In this case, of course, up to closing, it's very common that you could substitute a new party in or something like that. All of it has to be examined. And then there's a process to go about doing closing. So we are the agent that ensures that all that process is done correctly.
And Ed, did Trinity Title open the title orders in this case on the basis of treating the January 5th buyback agreement that was entered as a court settlement as the definitive contract to be administered or to be followed?
That's correct.
By the title company.
That's correct. And when we did open it, we give it what we call a GF number, which is a guarantee file number. And that's kind of Texas Department of Insurance language. But basically, we open the order because we have a signed agreement. We have purchase and seller for agreed price, agreed property. We've got everything we need.
And so at or around that time, did you have an opportunity to review the statutory buyback offer dated January 5th to determine whether or not it had all of the essential contractual terms in order to effectuate a real estate buyback?
It did. And what also, based on that, that's what we opened, or we had identifiable buyer, seller for a specific piece of property and at a specific price. So.
And was when the title company, after the title company opened title, can you tell the court who the title company determined to be the buyer in this transaction?
I think Versailles Homes or Versailles Dallas. I'm not positive of the entity's correct name, but it's Versailles for sure.
And at some point in time, on or about February 26th, did Trinity Title receive a series of calls or requests from a Sam Elchami?
Yes, I believe we did in that time frame. Yes, we did.
Okay. And can you tell the court generally what kind of requests was the title company receiving from Mr. Elchami at that time?
We were receiving requests to see if we could do some type of assignment from the buyer to another entity. And by the way, that happens all the time. And 99% of the time we can, because both parties want it to go forward.
And so, Ed, did you, after Trinity Title received that request, for compliance purposes, did you review the statutory buyback offer dated January 5th to determine whether or not this was on the purchase portion of the transaction, this was a purchase that was to be made by Versailles Dallas Inc. as the contractor, or was this an offer to that Versailles Dallas Inc. and or assigns would buy back the property?
It's my understanding that Versailles Dallas Inc. was, I think you just corrected me. I thought it was Versailles Homes, but I think the entity's correct name is Versailles Dallas Inc. And it's my understanding that was to be the buyer. I do recall discussions about an assignment, and I even sent over just a blank, a form, but it needs to be filled in. That was an assignment assumption agreement, because at the time I'm trying to just be customer service friendly. In other words, I'm trying to just say, if you want to do this, here's the form that I'd suggest you use, or that we could accept.
And so, Ed, did you also communicate to Sam Elchami, or have your staff communicate to Sam Elchami, that if they wanted to amend or change the purchaser on the buyback agreement, they would need to get with the Zatoons and their counsel to make amendments to the documents that were originally agreed to?
Yeah, let me be clear. I don't think that I've actually spoken to Mr. Elchami, but I know that those discussions were had because I was hearing from our assistants, how do we do this? How do we do that? And I said, well, send them the assignment assumption agreement and then tell them they need to get with their attorneys, get with the other side, fill all that out and get it back to us. And we're off to the races again.
Did you, to your knowledge?
I'm not following you, Mr. Lang. So I just want to make sure I understand what you're saying. Who are you saying that they need to get the assignment assumption agreement from? Were they needed to get it from the Zatoons, or getting it from the Versailles?
I'm sorry, I was unclear. I gave the assignment assumption agreement to Lori Chris and Angela Rubeck. That's the escrow officer and the assistant. They were to circulate that agreement among both parties. In other words, that, yes, we can amend the contract and that can be the agreement if the parties agree to it.
And then why? So you had no problem, or the title company had no problem with there being an assignment, but the parties couldn't agree that there would be an assignment. Is that right?
I think that's correct. Probably a title company certainly doesn't want to stand in the way of closings. So if a party comes to us with difficulty, we sit there and say, well, let me show you how we could do that. So that's why I circulated that assignment assumption agreement.
And who refused to allow the assignment to go forward? The Versailles or Zatoons?
I don't really know who refused. I just know that we never got it back. I
But-
never got the
But as
assignment.
long, if you had gotten that form back, you could have gone forward with a different entity closing on this deal. Is that right?
If the parties had agreed to a different, if the parties had agreed to change the contract, then yes, I think we could have.
All right, so let me do this. I need to take a break. Mr. Lang, are you okay for a few more minutes? I
I'm
need to
just
take a
fine.
break.
I'm just
All
fine.
right. So let's go ahead and take a break. We'll reconvene in 10 minutes.
Thank you.